Welcome to this webinar about the Partner Assault Response Program. In this webinar, we are going to be exploring what the Partner Assault Response Program is, also known as the PAR program. Throughout this webinar, I will be referring to this program as the PAR program. The information provided in this webinar is not legal advice, but legal information only. This webinar will provide general information and is not meant to be used for specific legal matters. Please consult with a lawyer if you have questions about your specific legal matter. Due to the constantly changing nature of the law, the Barbara Schleifer Clinic cannot guarantee the legal accuracy of this information outside of November 2024. The objective of this webinar is to provide an overview of what the PAR program is and provide clients and the public generally with access to a trauma-informed legal resource that may be relevant to their circumstances. First, I will be providing an overview of what the PAR program is. Next, I will review what the referral process entails, as well as the structure and topics covered in this program. I will then review how partner contact is managed while someone is going through the PAR program, as well as what happens if someone does not complete the program. Finally, I will go over some critiques of the PAR program, issues around accessibility and inclusivity with the PAR program, and why PAR is not always appropriate for criminalized survivors to participate in. PAR, or PARS, otherwise known as the Partner Assault Response Program, is a specialized court-mandated group counseling program for accused persons in response to a criminal charge involving domestic violence. It is a component of Ontario's domestic violence court process. People ordered to participate in the PAR program are often charged with domestic violence-related offenses. PAR can also be known as early intervention, and depending on the agency administering the PAR program, it may also be called alternative early intervention, domestic abuse program, domestic involvement prevention program, turning point, or next steps. Though there may be other programs offered by agencies across Ontario with similar names and aims, only those that are ministry approved will be qualified as being a part of the PAR program. Only approved PAR programs will satisfy the court-mandated requirement for those charged with a domestic violence-related offense. The difference between PAR and other counseling or anger management programs is that other programs are usually not government certified or monitored, not directed to those with domestic violence-related charges, or are not affiliated with victim services and are not required to contact the victim as part of the program. When a person has been charged with a domestic violence or intimate partner violence-related offense, such as assault, they may be ordered to attend and complete a PAR program. Referrals are often completed through a Crown attorney, through the domestic violence court, or by a probation officer. Someone may be mandated to attend PAR as part of their probation order, or an accused will be required to complete the PAR program before entering into a peace bond or other resolution. As PAR programs are considered a form of early intervention, the Crown will likely refer an accused person to a PAR program if they have no prior convictions for intimate partner violence-related offenses, have not caused significant injuries or harm, and have not used a weapon. The Crown may occasionally not refer an accused person to a PAR program if the Crown believes it will not be beneficial for the accused, or that a PAR program would not be appropriate in the given circumstances. The accused progress is shared with the referring source, whether that is the Crown or the probation officer. This can mean necessary communication happens between Crown attorneys, victim witness assistants, probation staff, and the PAR program. Agreeing to participate in a PAR program does not always mean the accused person is guilty of the offense they are being charged with. These programs are often required as a result of negotiations between the accused and the Crown in order to resolve the charges in a way that is potentially less detrimental to the accused person. What if an accused person does not want to agree to PARs? An accused person's ability to avoid being mandated to do a PAR program will depend on the facts of their specific case and the negotiations that are taking place between the Crown and the accused lawyer. A negotiation's outcome can result in any number of potential resolutions to a criminal matter, with PAR being only one component of that resolution. Prior to being able to start a PAR program, a few things must happen. First, the accused person must have attended their first court appearance. Next, they must have received their disclosure. Lastly, the accused may only start the program after receiving approval from the Crown or probation officer affiliated with their case to enroll in PAR. An accused person cannot enroll in a PAR program on their own. They have to be referred to the program from one of these agencies or individuals. PAR programs are 12 weeks long, with weekly sessions lasting 1 to 2 hours, though they are typically closer to 2 hours long. Depending on the agency administering the program, there is also a possibility that the sessions are conducted virtually. Participants are expected to attend all 12 sessions in order to complete the program. Participants may also be assigned homework that they are expected to complete as part of the program. Depending on the group, sessions are facilitated by both male and female staff. PAR programs are offered in both closed and open formats depending on the agency. Groups include a minimum of 15 participants and can have up to 25 people at larger agencies. Some topics of PAR include domestic violence, defining abuse, how beliefs and attitudes affect behavior, effects of abuse on children, partners, and self, understanding triggers and warning signs, impact of substance abuse, healthy relationships, respectful communication, dealing with conflict, and responsibility and accountability. Do I have to pay to attend PAR? Yes, there is a cost to attending this program. To determine cost, participants are typically asked about their income during a consultation meeting. The cost of the program is based on the participant's income. Some programs also offer financial assistance if finances are a barrier. Many extended health benefit programs also cover this program. If you feel like you need to, please take this moment to take a break. If you do not feel like you need a break, please skip forward. However, if you feel like you need to take a breath, or go for a walk, or get something to eat or drink, please feel free to pause here and come back when you feel ready to do so. What does PAR aim to do? PAR programs are intended for adults who have been charged with domestic assault or similar offenses that involve an intimate partner. The program intends to provide the accused with an opportunity to examine their beliefs and attitudes and learn non-confrontational ways of resolving conflict. The focus of this program is to teach participants ways to resolve conflict, how to cope with conflict in relationships, and how to take accountability for their actions and reactions. Partner contact is a mandatory part of the PAR program. When a participant begins a PAR program, the client support worker or counselor contacts the complainant to offer support, information, and referrals to community resources. This is an opportunity for the complainant to ask questions and be informed on the program content, as well as be provided information on local services. Complainants are made aware of the participant's program start and completion dates, as well as any sessions that they did not attend. Depending on the case, the Crown may agree to varied bail conditions to allow the accused contact with the victim while they participate in a PAR program, especially after the participant has made at least some progress in the program. Participants are assessed based on how they engage with the program. Participants must attend all sessions and ensure they are attentive and engaging with the sessions. Those leading the program will report back to the Crown about how the accused person is doing in the program. At the end of the program leader will send a report to the Crown and will confirm if the participant successfully completed the program. Some things that may result in a person failing the PAR program are being disruptive during sessions, not engaging with material, attending under the influence of alcohol or drugs, or being confrontational or disrespectful to PAR staff or participants. The Crown will provide the judge with a copy of the report so the judge can confirm successful completion of the program. What happens after the accused completes the PAR program? This will depend on the specific facts of the case. It is important that an accused ask their lawyer what will happen after they complete the PAR program, or follow up with the Crown if they are self-represented. Program participation is often just one element of an accused person's resolution of their charges. Participation in the program alone is not an admission of guilt or a conviction. If an accused is removed from the PAR program or fails to complete the program for other reasons, they will likely face negative consequences. Participants may be discharged from the PAR program or be considered to have not successfully completed the program for reasons including failure to complete a homework assignment, being late for a group session, being disruptive in a group session on more than one occasion, assaulting or threatening their partner, attending a session while impaired by a substance, either alcohol or drugs, missing a session without a reasonable explanation or notification, refusal to pay the negotiated client fee, being abusive or threatening toward agency, staff, students, volunteers, clients, or other PAR program participants. A failure to complete a PAR program would likely have a negative impact on the outcome of the accused person's criminal charges. The Crown may rescind their offer or potentially enter new charges. The Crown may also ask for a trial, whereas they may not have originally done so. If you feel like you need to, please take this moment to take a break. If you do not feel like you need a break, please skip forward. However, if you feel like you need to take a breath, or go for a walk, or get something to eat or drink, please feel free to pause here and come back when you feel ready to do so. Now, I will go over some of the concerns with the current PAR program and how this program is not ideal for criminalized survivors. The PAR program, although necessary in some cases, is also a flawed program. Particularly, the PAR program has significant gaps in its curriculum for women-identified participants and criminalized survivors of gender-based violence and intimate partner violence. Further, this program lacks content, resources, and support for 2S LGBTQI participants and those not in cisgender heterosexual relationships who may be in abusive relationships. Lastly, it also does not consider the different ways that violence is expressed in different cultures or how gender-based violence manifests differently between cultures. I will get into details of each of these considerations in the following slides. One of the critiques of the PAR program is that it is not appropriate for women-identified accused persons. The PAR program is strongly oriented to male perpetrators of violence, rather than connect survivors to services that could benefit them after being charged. These women are often treated as perpetrators in the legal system, leaving little room for their stories and use of force to be contextualized. This also makes them ineligible for a variety of victim services. For the vast majority of female gender-based and intimate partner violence cases, PAR is an ineffective solution. Women and men engage in violence for different reasons. Women's physical violence is more likely than men's violence to be motivated by self-defense and fear, whereas men's physical violence is more likely to be driven by control motives. PAR programs are intended to increase victim safety and hold perpetrators accountable. When survivors are charged due to mandatory charging policies or a misidentification of the main perpetrator, PAR programs are fundamentally inappropriate for a survivor to participate in. It becomes especially inappropriate during the step of the PAR program that involves partner contact. Contact could endanger a survivor by notifying an abuser of their activity when they would be safer without their abuser knowing what agency they are engaging with and when. Such a step provides avoidable opportunities for abusers to potentially sabotage the survivor, such as interfering with their attendance or reporting false allegations of new acts of violence. Further, these programs recognize victims and their families to be the primary clients and the accused as the secondary client. Therefore, it is evident that the program structure ends up further silencing and re-victimizing survivors when they become PAR program participants, as they are perceived as perpetrators of violence rather than victims. This means that the actual victim is not helped for the violence they have endured. For gay men and lesbian women who are both the victim and the defendant, in order to complete the PAR program is particularly problematic. Not only is the content inappropriate, but participation can be harmful and detrimental because of homophobia that could be expressed by heterosexual PAR participants. As a result of the usual heteronormative framework of abuse within the PAR program, many 2S LGBTQ women express confusion about whether their experience falls within the PAR categories. The mainstream PAR model is limited, if not mostly inapplicable, for 2S LGBTQ relationships, as it explains intimate partner violence between male abusers and female victims. To give information and resources designed for heterosexual relationships to those in 2S LGBTQ relationships is problematic. The cis heterosexual experience does not reflect the gender identities, sexual orientations, and unique dynamics of 2S LGBTQ intimate partner relationships. Many of these relationships do not follow the heterosexual gender roles. Therefore, this approach fails to identify and challenge the many forms of power that shape 2S LGBTQ relationships. Many 2S LGBTQ folks also have concerns that, quote, airing their dirty laundry could cause further discrimination and marginalization. This is because the program caters to those in heterosexual relationships and expectations of acceptable behavior in those relationships. Without considerate and informed programming for 2S LGBTQ people, PAR programs can become sites of harmful perceptions regarding what is normal and healthy. In its current state, the PAR program is designed for a white male audience. The content does not address differences in intimate partner violence across different cultural groups in Canada, and how violence manifests differently across different groups. In order to meet the needs of newcomer and immigrant women and families affected by domestic violence, it is important to meaningfully engage a diversity of voices from their respective communities and the local service providers within that community. Integrating an understanding of values and concerns of the diversity of communities in Canada enables a program to respond to these communities in a way that is meaningful and engaging. There are some Indigenous-specific PAR programs that are offered by community organizations. For example, Family Assault Support Services, Anishinaabe-Gamut Friendship Center, and Native Child and Family Services of Toronto offer Indigenous-specific PAR programs. This is not an exhaustive list, and there are other organizations who offer PAR programs with a focus on supporting Indigenous people. Please look into which programs are offered in your area if this is something you are seeking. To summarize, the PAR program is often a component that those accused of domestic violence-related offenses are required to complete in order to resolve their charges. The programs are group counseling sessions and happen over a 10 to 12-week period. The program covers a variety of topics such as healthy communication and conflict resolution. Participants must successfully complete the program. Failure to successfully complete the program could result in consequences for the accused. Currently, the program's content is geared towards white male perpetrators of violence. The content is not tailored, not appropriate for women accused, gender diverse, 2S LGBTQ, and racialized accused. This concludes the webinar about the PAR program. For more information, please visit the Criminalization of Women Project webpage on the Schleifer Clinic website.